Explain the significance of the High Court's decision in ARCY and MYRIAD genetics. Well, first a little bit of background to the case. So who are our actors? Well, Miss Darcy is a breast cancer survivor. MYRIAD Genetics is a molecular diagnostic company. The impugned claims. So through years of research, MYRIAD identified that mutations in a gene known as the BRCA1 gene predispose women to an increased likelihood of breast or ovarian cancer. MYRIAD patented its discovery in an application covering 30 claims. The first 3 claims were over nucleic acid sequences containing the mutations. The remaining 27 claims were essentially to genetic tools that arose from application of the discovery and could be used in diagnosis of the concerned mutations. So what did Ms. Darcy argue? Ms. Darcy argued that isolated nucleic acid, as described in claims 1 to 3 of the MYRIAD patent, were not materially different to cellular nucleic acid, and that naturally occurring DNA and RNA, even in isolated form, are products of nature that could not form the basis of a valid patent. So what did MYRIAD argue? MYRIAD argued that the claim was to a product which was a chemical compound which has no counterpart in nature. In particular, covalent bonds were broken in isolating the nucleic acids, pieces of DNA known as introns were removed, and once isolated, the DNA could not function to produce proteins as it would in the cell. So what did the court say? The High Court unanimously held that claims 1 to 3 must fail. 3 judgments were delivered, but a number of themes ran throughout. Justices Gageler and Nettle were concerned that the claims could not properly be characterised as being an invention at all. Chief Justice French and Justices Kiefel, Bell and Keane framed this another way by interpreting the claim as being a claim to information, holding that information was not patentable subject matter. Justice Gordon characterised the subject matter similarly as ideas simpliciter. Secondly, the High Court noted that the claims were merely the end result of an already well-known process of DNA extraction. Related to this was a concern that a researcher might inadvertently infringe the patent if, through use of a well-known extraction technique, they happen to extract naturally occurring segments of DNA carrying MYRIAD's mutations. Justices Gageler and Nettle referred to this possibility as the antithesis of a man-made artificial state of affairs. So what is the significance of the decision? Well, the significance of the decision really depends on who's asking. For patent attorneys, the decision means that genetic material, generally speaking, is unlikely to be patentable. With this noted, applications of genetic discovery, such as the content of claims 4 to 30, will remain proper inventions capable of patent protection. For intellectual property lawyers, it means that caution needs to be applied when interpreting previously held tests relating to patentable subject matter. In particular, the test in National Research Development Corporation and Commissioner of Patents that a manner of manufacture result in an artificially created state of affairs of economic significance is overly simplistic. For scientists, it means that they can legitimately conduct research that involves isolation of mutated BRCA1 nucleic acid and potentially develop new products, so long as those products don't infringe any of the other 27 of MYRIAD's claims. For the public, this is likely to reverse any chilling effect that MYRIAD's patents had on breast cancer research and hence widen the scope of services available to patients. In particular, secondary or confirmatory testing will now be available. There is a lifting of the monopoly and corresponding decrease in the cost of genetic testing. And finally, there would be decreased mortality and morbidity rates.